that's a great question. So what the FDCPA does, it allows you to recover at least $1,000 if the debt collector violates the law. Also, you can recover any kind of actual damages. So if you're out of pocket any money because they lied to you, then you can get that back. If you have severe emotional damages because you're losing sleep at night because of all of this harassment, they're bombarding you with telephone calls and you can't get them off your back, sometimes that can be compensated as well.
What is an FDCPA violation?
So the FDCPA stands for the Fair Debt Collection Practices Act. And that's just a long name for the federal law that governs what debt collectors are and are not allowed to do. So one common violation that I hear all the time is somebody might come up to my office and say, yeah, I was on the phone with this debt collector and they threatened me with jail time if I didn't go pay this debt. That is a clear violation of the Fair Debt Collection Practices Act. That you can't jail somebody, you can't threaten them with jail. First of all, let me point out that this law only applies to debt collectors. So if somebody's coming after you and they're the original creditor that you did business with, they're exempt from the FDCPA. So I want to make clear that we're only dealing with those debt collection agencies that contact you, that are hired out later after you're in default. But once they come into the picture, some of the more common violations that we see are, for instance, misstating the balance. If they're inflating the balance in any way by kicking up the interest or padding it with collection fees that they're not authorized to put in there, that's a violation of the FDCPA. Any kinds of false statements about your rights. Now, this is something I think that pops up a lot with student loans. Sometimes they just don't take the time to understand what a borrower's rights are, so they misinform people about them. But for instance, they might tell you that your loans can't be discharged in bankruptcy, and that's not true. It's hard to discharge student loans in bankruptcy, but it's possible. So for them to say flat out that you can't do it, that's a common FDCPA violation we see with student loans specifically.
So let's say someone does have an FDCPA violation. Why should anybody watching this care? How does that impact them?
So that's a great question. So what the FDCPA does, it allows you to recover at least $1,000 if the debt collector violates the law. Also, you can recover any kind of actual damages. So if you're out of pocket any money because they lied to you, then you can get that back. If you have severe emotional damages because you're losing sleep at night because of all of this harassment, they're bombarding you with telephone calls and you can't get them off your back, sometimes that can be compensated as well. The other good thing is that there's a provision that allows for attorney's fees in the FDCPA. And that's good because what that means is that you can oftentimes find an attorney, I guess such as myself or other consumer law attorneys, to take the case on a contingency basis. So
what does a contingency mean for people to know?
So basically what that means is that you don't have to pay the attorney unless you win.
Wow, so kind of like the personal injury stuff, right? Like you don't pay anything unless you get an award in some cases.
Exactly.
Yeah, depending on the case, right?
Right.
Yeah. So does that mean that borrowers have some rights when it comes to what happens with these collection companies calling them?
Absolutely.
So I think a lot of people feel so victimized and they feel scared and they get bullied by collection agencies. That's something that we're really passionate here with student loans, and that happening with servicers and collection agencies and the Department of Ed, being able to help teach borrowers what they could do, what their rights are, what options they have, and helping understand the craziness surrounding student loans.